Anybody know this person? And this person, that's Thomas Jefferson. And then you may wonder what connects Cyrus the Great to Thomas Jefferson. And the answer is this third picture. Not me, but what I'm staring at. And that is one of the most valuable historical documents. It's called Cyrus Cylinder, right? Cyrus Cylinder was issued upon the conquest of Babylon by Cyrus. This was 539 BC, okay? And what it did was to acknowledge that everybody had to be treated equally, and he gave some sort of privileged protections to women and children in that cylinder, in that declaration too. Also, what he did in that declaration was to pay respect to the gods of Babylonians. So that was unique in ancient history, because in ancient history, if a power would take over another country, one of the first things that they usually did was to destroy their temples. But here we had a groundbreaking change. For the first time in the history of civilization, a conqueror actually issues a declaration in the name of the gods of the people who he has conquered, right? And then he pays respects to the god of Babylonians, whose name was Marduk, right? And he curses the previous emperor of Babylon, whose name was Nabonidus. You don't need to know these names. Another important thing that he does in this document is to free the Jewish people from captivity. Jewish people had been enslaved by Nabonidus and had been exiled. They had been taken from Jerusalem to Babylon. Babylon is, roughly speaking, Iraq and Syria today, right? And so when he conquers Babylonians, he issues this declaration. It is believed that the Cyrus Cylinder in 539 BC is the first major historical document in which certain category of human rights are recognized. And how does this relate? So this is the Cyrus clay, actually. And this is in London British Museum. The clay was itself discovered in 1879 accidentally, but it changed how we looked at ancient history. How does this connect to Thomas Jefferson? Well, Thomas Jefferson was impressed by a book written about Cyrus called Cyropaedia. And this had been written by a Greek philosopher named Xenophon. And Xenophon was one of Socrates' students who at one point in history went to fight as a mercenary for Cyrus III, the great-great-grandson of Cyrus the Great. And there he hears about Cyrus and what he has done, and he writes a book about Cyrus, his doctrine of ruling. Another thing and he mentions one important thing, and then the Cyrus clay actually approves that. He says that Cyrus created a sort of religious tolerance. So in a way, the first, not secular, but the first multicultural international order. So actually for centuries, that became the doctrine of conquest by Persians. Persians' claim was that we conquer other nations to respect their gods and to help their gods flourish. So this actually was in the ancient world an equivalent of multicultural tolerance. This is as close that it could get to the idea. So, and this becomes actually inspiring for Thomas Jefferson. So in a way, Thomas Jefferson drew some of his ideas that were later articulated in American Declaration of Independence and First Amendment from ancient history. Moving on, this is the content of the clay. This was actually written in Akkadian. That was another Akkadian. Another interesting fact about this clay is that it was written in the language of the people who were conquered. Okay, and the language was Akkadian. Then in Rome, you have an important piece of legislation. So this is 800 years later. And some interesting development also is happening in ancient Rome. Just going back to what I was saying about Cyropedia. Some people say that when Xenophon wrote Cyropedia, what he wanted to do was actually to critique the Greek system of democracy. So he was saying that in a way Cyrus was a Platonic ruler, and this was a system that would outdo Greek democracy, right? But democracy, of course, survived in Greece and was transferred later to ancient Rome. And in ancient Rome, you have the system of governance mostly by a republic. And then in Persia, you have the monarchical system. And of course, different rulers take different approaches to religious minorities in the ancient world. One of the metrics for judging a civilization is how they treated minorities and religious somehow religious outsiders and heretics. And in ancient Rome, you have this long persecution of Christians. And this is actually, this reaches its peak through the rulership of a Roman emperor called Diocletian. Okay? After Diocletian, you have Constantine. And what Constantine does is to unite the Roman sphere of influence. He first declares that Christians are free to exercise their religion. And this is basically the case, this becomes the case in 313 CE. This is a very important date for Christian history because this is the first time the Christians can finally have the right for exercising their religious freedom or to coexist peacefully with other religions in Rome. Not long after that, Christianity conquers Rome and itself becomes a major tool of oppression. Beforehand, the Roman Empire had this religion called Mithraism. And this was a polytheistic religion, right? And through that declaration, Edict of Milan, Christianity slowly but surely comes and takes over and somehow wipes out that older generation, that older religion of the Roman Empire. And well, this is a very interesting passage that I like. I read it for you just for the fun of it. We thought it fit to commend these things most fully to your care, that you may know that we have given to those Christians free and unrestricted opportunity of religious worship. Well, the importance of Constantine for the history of Christianity is such that he was later called a saint. So he is now considered as a Christian saint. Moving on, this is where things somehow emerge out of being mere ideas into something much more robust and concrete. And we have this great charter, one of the most wonderful achievements of European civilization, though perhaps most readily associated with Britain and Anglo-Saxons. And what's happening here is that King John of Angevin dynasty in Europe, in Britain, that has French roots, he is at conflict with landowners and feudals of Britain, and they're called barons. So barons in Britain were these major landowners who really owned the country, right? And King John of the Angevin dynasty decides to raise the taxes on them. Why? Because he's fighting crusades and he's taking a few defeats here and there, and he has to sponsor these wars by raising taxes. 25 barons, these richest of the rich, basically decide to go against the king, and they bring their troops along with themselves to London, and they occupy London. And they say, we won't leave London until the king will make certain promises to us. So the king, and this is a depiction of what happened in signing the Magna Carta Charter. That original document is still alive. We can see it, I think, in the British Library. So they sit together and King John signs these documents, basically containing a set of promises to the barons. And basically some of the most important provisions are clause 39, clause 61. For example, clause 39 says that no free man shall be in prison except for the judgment of his peers. And basically what it's saying in the 13th century is that the king doesn't have absolute power in treating its subjects. Subjects are entitled to due process. That was groundbreaking. This was in the 13th century, in the middle of the Dark Ages in Europe, and a king still makes that promise to his subjects. The Great Charter of Magna Carta was never implemented, sadly, because the king would say, I won't implement these promises until barons will leave London, and barons will say, we won't leave London until the king will fulfill his promises. And basically this leads to, escalation of clashes between barons and the king, and eventually the Angevin dynasty is toppled in United Kingdom, right? But one thing that the Great Charter does is to create a discourse. Now, the English had a sort of language to refer to rights. This was very interesting because the Great Charter wasn't meant to govern the relationship between regular subjects and the king. It was meant for protecting those major landowners, right? So what's happening here is that we have the birth of idea that liberties are recognized through status. So to enjoy liberties, you need to have a certain status in your society. If you're a major landowner, if you're rich, if you're wealthy, if you have power, good news is that the king has promised certain liberties to you and he has guaranteed them for you. For other individuals, this won't become the case until much later. But still, the Great Charter of Magna Carta is still a great achievement because it creates a discourse for rights. And what happens is that because the common law is basically growing, but at the same time now you hear British subjects, king subjects, and it's as if subjects of the king are protected by the king, right? So through time, British people refer themselves as subjects of His Majesty. And what does that mean is that I've been promised by the king to have my rights guaranteed. And this was important. This was important for the age, but it took much longer. I already mentioned that. It also created a very interesting philosophical dilemma, though the dilemma in philosophy goes far more back in time, but it finds an interesting parallel in law. The dilemma is called omnipotence paradox. And the basic idea is, the question is, can God create a stone that He cannot lift? So the question is, can God make a stone that He Himself cannot lift? This is a very serious dilemma in philosophy. And here, basically, the religious mind is locked into a very difficult question. Because if God cannot lift a stone that He has Himself created, that means that God, after all, is not all-powerful. And if God can lift the stone that He has created not to be able to lift, then that means that God wasn't, after all-knowing, right? So, very serious question in philosophy. And in theology, there are 100 different answers to it. But why that relates to law? Because the question for us then becomes, when the king creates laws, can the king himself violate the laws that he has created? So the king comes and tells you, suppose I'm a king, I come here and tell you, well, my subjects, today I had a very good sleep, and for that reason I want to promise you liberty. I want to promise that I'm going to diminish your taxes, give you all sorts of privileges and all that, right? I have created law. Now, as a king, am I bound to the law that I have created? Or I can violate the laws that I have myself produced? Okay? And this became a major question again in Britain in the 17th century. And again, a case which actually plays an important role in creating the discourse of human rights. And this is in the 17th century, during Charles I's reign in England. What happens here is that Charles I lends money to his Scandinavian cousins, to kings of Norway, Denmark, and all those types of countries. And the basic premise here is that they fight the French and they will basically deal a defeat to the French. that doesn't happen. On the contrary, Scandinavian kings are conquered by the French, and that money has been paid off by king, and now the king is bankrupt. Country doesn't have much financial resources, and what he does, he will raise the taxes, right? So in the 13th century, we already saw how raising taxes really, turned the entire politics of England upside down. And here again, we have another interesting case by Charles I. And British House of Commons, which was back then anything but a House of Commons, it was a house of big lords, and again, wealthy, rich, prestigious, powerful people, they take issue with that. They say that we don't want our taxes to be raised, and the king is doing this unlawfully. And they start, I've gone through all the 17th century debates of the House of Commons, and they're amazing in terms of the richness of literature and how these individuals debated one another in the 17th century. Mind-blowing, mind-blowing. So these people start debating how they are going to treat the king, and this beautiful debate erupts in the House of Commons with some representatives saying that, well, he is the king, we cannot do anything against king's will. The king promised to give us liberties, now he has taken away those liberties. He is the king, he has the ultimate say. And then there are certain other representatives and British novels who say that, well, he is the king, but the law is the law, and the common law recognizes the king. It's the law that matters more than the king's prerogative and powers, right? Now, the king, worried by all of that, decides to detain 5 members of the British House of Commons. That's Charles I, right? And this becomes the case of 5 knights, okay? 5 knights. And because those were, part of the British royalty, they were called knights. So 5 knights of Dornell, 5 knights are detained. Now in Britain and in common law after Magna Carta, an interesting tradition, an interesting legal tradition emerged. And this tradition was for the king to guarantee the liberties of individuals through a document that we call writ of Habeas corpus. So writ basically means a judicial order. So an habeas corpus, if I want to translate this into simple English, the right to have your detention reviewed by a court. So the right of detainees to have their detention or the legality of their imprisonment reviewed by a court of law. So how this happens? When a British subject is detained, he is taken to a jail, the court sends a document that's called writ to the jailer and asks the jailer to specify the reasons for the detention of these detainees. Okay, you got the idea? So a person is arrested, okay? Then he is sent to a jail. The court sends an order to the jailer, okay, to the jail guardian or to the protector of the jail, and asks him to specify the reason for this person's detention. That was one of the liberties promised by the king to his subjects. And this was for the king to protect his subjects. Okay? This became such a valuable document in the history of common law that really it's no exaggeration to say that the entire history of common law in a way is the history of the writ of habeas corpus. The entire history of common law. And if you look at all the major political disruptions before the 20th century in England and British colonies, all of them involved the writ of habeas corpus. I don't know, the document is scarce. There's something about it, right? All major, so independence of India, American independence, uprisings in Jamaica, South Africa, Kenya, all of them involve major disputes about how colonizers choose to apply the writ of habeas corpus. This also applies to all major political disruptions in England before the 20th century. There is some version of the writ of habeas corpus always involved in political disputes. Here, the king orders the court not to issue a writ of habeas corpus for the 5 individuals who've been detained. So these individuals are detained. Now, Charles I says that no habeas corpus for them. And this maddens the House of Commons. The House of Commons goes mad, or really, really finds this disrespectful and thinks that king is violating his own laws. And again, a new set of debates erupts in the House of Commons. Can the king do that? Can the king suspend his own laws? Can the king order the writ of habeas corpus not to be issued for subjects? And this actually results into the king withdrawing from the dispute. And in 1628, in Britain, you have the Petition of Rights. So 1628, Petition of Rights. This is the closest thing to the modern Declaration of Rights. So through Petition of Rights, in 1628, the king again promises a new version of liberties and rights to his subjects. That's 1628. Of course, the dispute between Charles I and House of Commons was never really resolved. And this led to the Civil War in Britain, which finally ended with beheading Charles I, the first and the last king in the history of Britain who've been murdered by revolutionaries. And actually, the trial of Charles I is one of those historic moments in which, you see somehow time stop. He gives a beautiful speech, Charles I makes a beautiful speech in his trial. And that's one of the most memorable speeches in the entire political history. He says to those who tried him that today you turn me from a corruptible king into an incorruptible one. Basically saying to his executioners that by killing me, you're giving me eternal life. Well, history, Charles I, and here is a portrait of Charles I, has been portrayed as this weak king in British history, where he wasn't that weak. He was more liberal than many other kings in the history of Britain, and he decided to issue a few very important human rights documents. Of course, for a little while, there was no monarchy in England till Britons realized that they couldn't do without a king. And they restored monarchy in England in, I think, 1671, if I'm not mistaken. Or 1670s. And then a similar dispute again happens over the writ of habeas corpus in 1686, and in 1686, and then it goes on for 2 years, and in 1688 you have the glorious revolution of Britain, following which Bill of Rights is approved. So in the 17th century in Britain, you have two important historical documents: British Petition of Rights and British Bill of Rights, one in 1628, one following the Glorious Revolution of 1688. So two major historic documents containing the earliest versions of political rights. And that became pertinent also for, so Britain, has its own history, but history of Britain also informs, unfortunately, much of the world's history through colonialism, right? So this dispute over the writ of habeas corpus was exported to these different regions. Now remember that the Brits invaded other countries by the excuse that they could give these colonial people more rights. And one of the first things that they would promise to these colonial subjects was the writ of habeas corpus, right? So they go to these colonies, they issue something of a declaration, and they promise colonial subjects that if they are detained, the detention will be reviewed by a court. Right? And this was somehow appealing to subjects, even though it was repressive by nature, but people really didn't have that much protection back then. A king could, decide to kill you for no reason if he didn't like you. Now there is a power, a political power that promises you something, and you may take a liking to that. But then the Brits would part with their promise whenever they could. So whenever there was a big crisis in the colonial societies, the first thing that the Brits would do was to suspend the writ of habeas corpus. And when that happened in the United States over another tax dispute, the Stamp Act, and American subjects, American colonial subjects were detained without the writ of habeas corpus when they were protesting the decision of British colonizers to raise the tea taxes in the United States. When that happened, America decided to go to war with Britain, and that led to American independence. The same holds true for India. And this is very interesting too, because before the First World War, or in the midst of the First World War, British politicians say to Indian politicians like Gandhi, like, activists, tribal chiefs, landlords, they will tell them that once the war is over, because you have decided to fight on our side, we will give you independence. And the war is over, and Britain does not fulfill its promise. What happens? New wave of protests occur in India, and again what happens here is that the writ of habeas corpus is suspended. This is actually 1919 Amritsar massacre in India, when Indian subjects object to British decision not to give them independence, and then you have the Amritsar massacre of 1919 and the political events that unfold after that. So that's the story of 17th century. And there is one thing that we can learn here. With very little time, but I'll try to summarize this. Of course, we'll continue this more on Wednesday. And on Wednesday, I make sure that you'll watch the video too. One thing that we can learn here is that the first generation of human rights, whether it's Cyrus the Great or Charles I, really relates to negative liberties, negative rights. And there's nothing evaluative about the term negative here. We don't mean that these are bad rights. What we mean is that when somebody has negative liberties, the state or the sovereign is obliged not to interfere with their rights. So if I have a negative notice how I said freedom from arbitrary detention, that means that I have a right not to be detained arbitrarily or unlawfully. So that's my negative liberty. When I have a negative liberty, that means that the state has a duty not to interfere. Okay? Or I have a right to be free from torture. That means that the state has a duty not to torture me. Or I have a right or freedom to be free from arbitrary death. I have a freedom from arbitrary death. That means that the state has a duty not to intervene arbitrarily so as to deprive me of my right to life. So that's negative liberty. And the first generation of rights, as manifest in the 17th century disputes, relates to these negative liberties. So when British citizens claim their entitlement to the writ of habeas corpus, it was saying to the sovereign that you have a duty not to detain them arbitrarily. That's a negative liberty.